Have your children been taken by family court? Or CPS? Hear me now. It is not over. This is not the end of your story. It's the beginning of your counterattack. There's a word that can turn the tables when the system steamrolls you. Jurisdiction. The good thing about it is, it has no statute of limitations. Yes, you heard me right. And when a court acts without it, or without the constitutional process that gives it legitimacy, its orders can be challenged and vacated. Today, I'm going to tell you about the Get Your Kids Back offensive packet. It's not just paper. It's a plan. It's strength in your hands when everything feels like it's slipping away. This packet gives you a lawful way to force the court to prove its power, to restore real due process, and to demand a fair hearing. Not next month, not someday. Now, here's the hard truth. Families are losing children on the basis of unsworn hearsay, coerced interviews, and rubber stamp ex parte orders that never face a real evidentiary test. That is not due process. The Constitution demands notice, a meaningful chance to be heard, and a neutral judge. You are entitled to present witnesses, to cross-examine, to see the evidence against you, and to stop the use of illegally obtained statements. The offensive packet is designed to do exactly that. It contains laser-focused filings that compel process, not outcomes, so you can get back into a lawful arena where facts are tested, truth matters, and constitutional standards apply. What's inside the packet? First, the emergency motion to vacate void orders, reopen proceedings, and for immediate return of minor children. Or, in the alternative, an expedited evidentiary hearing. That's a mouthful, but it's your opening strike. It tells the court, if you acted without jurisdiction, without a neutral judge, or without real due process, your orders are void and must be vacated. Reopen this case, put us in front of a neutral adjudicator, and set a prompt evidentiary hearing with full rights, witnesses, cross-examination, access to evidence not hearsay, not rumor. This is how you force process back into the room. Second, you get the notice tools, including a comedy notice to the state court, and a scary federal complaint, if your voice is not heard. You will also get a federal TRO preliminary motion. The state judge won't know what hit him in the behind. Injunction motion that asks the federal court to compel process only, a fair hearing, a neutral judge, access to discovery, and a ban on using unsworn hearsay or coerced statements as a substitute for evidence. We use process-only injunctive relief so you don't trigger abstention problems. You're not asking a federal judge to decide who wins custody. You're asking the federal court to protect the Constitution while the state case proceeds properly. That's how you get traction fast. Third, you get routing and jurisdiction notices that force the system to stop hiding behind titles. If a judge is acting like a constitutional court, the judge needs to say who they are, what authority they have, and what standard they are applying. No more just trust us. Put it in writing, on the record. If you're listening to this, you've probably already been talked over, ignored, or intimidated. You might have felt pushed into consent or watched your evidence get blocked while agency stories go untested. You might be exhausted, out of money, and out of patience. I get it, but you're not out of options. This packet is built to teach and empower, not just to file and hope. Every template includes plain English instructions. It explains when to file, where to file, and what to attach. You'll learn how to demand a prompt evidentiary hearing, insist on a neutral, independent adjudicator, suppress illegally obtained statements and coerced interviews, compel discovery so you can actually defend yourself, and lock every step into the record so your rights are preserved and enforceable. And here's the mindset shift. You are not begging. You are asserting rights that already belong to you, the oldest of our fundamental liberties, the right to raise your children and protect your family. This is about courage. Courage to say, no more shortcuts, no more hearsay as proof, no more forced consent, no more orders from a tribunal that won't even put its authority in writing. Courage to say, We're going to do this the right way, before a neutral judge, with real evidence. The offensive packet helps you do exactly that lawfully, tightly, and immediately. You'll be ready to file the emergency motion that reopens the case and challenges void orders. Serve the comity notice, so state court knows you filed federally for process protections. Move in federal court for a TRO preliminary injunction that compels a neutral hearing and discovery without asking the federal judge to decide custody. And, if the court refuses to follow the Constitution, you'll be positioned to escalate with a Perv 1983 civil rights action for ongoing violations. I'm not telling you the road is easy. I'm telling you it's possible. There is light at the end of this tunnel, but you must keep moving. You must stay steady, organized, and relentless. File, serve, document. Keep your voice calm and your paper sharp. Let the record carry your voice into every chamber you stand in. This is your wake-up moment. If they took your children without a lawful evidentiary hearing, if your judge won't identify their authority, if CPS uses intimidation at your door, fight back with law and with process. Get up and get your kids back. Get the offensive packet now. Don't wait for the next hearing to steamroll you. Walk in prepared to force jurisdictional clarity, to restore due process, and to demand a fair evidentiary hearing with real rules and real rights. Your children deserve a parent who won't quit. Your voice matters. Your rights matter. Rise up, file strong, stand firm, and fight back with authority. And get your kids back. Thank you for watching, and we will see you in the next video.